May it please the Court, my name is Ira Zalesnik, and I represent the defendant, appellant, town of Saugus. At issue in this case is whether the INI reduction contribution imposed by the town is a valid fee, regulatory fee, or an unlawful tax. The appeals court upheld the decision of the trial court concluding that the fee was in fact an unlawful tax, and the town contends that that conclusion is in error. As with the Emerson College case and the various cases following it of this court, the most important consideration to look at in this case is whether in fact the fee provides a particular benefit to the individual or entity paying the fee. And I would suggest in this case that the record is apparent that there was a very strong benefit to the entities paying this fee.
Is it the case that because of the department's regulatory proceeding that it wasn't just the town of Saugus saying you can't hook up unless you pay? I mean, that they would not have been able to, the town would not have been able to allow them. Is that right?
That's correct, Your Honor.
It was a state-imposed requirement?
It was state-imposed, but it also was imposed by the facts on the ground. The system, as it stood at the time, was overcapacity. And that means not that on a day-to-day basis that there would be overflows in the sewer system. What it meant was that during what the environmentalists like to call SSOs, in storm events, there were sanitary sewage overflows. And so particularly in extreme rain events, which we've seen quite a few in the last number of years, the system would overflow. It could not handle the capacity, and there would be a discharge into the Saugus River, among other areas of critical environmental concern. So that
what is an extreme rain event? How much rain would have to fall before that would occur?
Well, I don't know the exact quantity of rain, Your Honor, but the way that the engineers measured it, and you see it in the testimony of the engineers, they measure it in terms of year events, a 10-year event, a 50-year event, a 100-year event. From the lay point of view, these 100-year events seem to be happening with increasing frequency, and there's been an enormous amount of flooding in recent years. But that is the way that they phrase it, and this order and the scheme was devised to deal with the 10-year event. So
aren't you playing right into Barry? You're saying the system was overcapacity, needed to be significantly corrected. There were backups, and I mean, isn't that what Barry says? You know, the corrections to the system are something that everyone in the system needed to have happen. The improvements in the system.
The difference between Barry and this case is that the particular fee in this case wasn't simply being devoted to system-wide improvements. And in fact, the significant difference between this case and Barry is that the scheme established in this case permits the city of the municipality to engage in long-range planning as opposed to necessarily short-range planning in order to provide people with access. Let me give an imperfect analogy. Let's say you have a street that's full of potholes and virtually undrivable. You could address that situation by filling the potholes, or perhaps the better remedy is to simply take the street, rip it up entirely, close it off, do everything that needs to be done in order to render that street good for the long term. If you say that cities and towns have to spend their limited resources on the short-term fix, filling the potholes, in order to provide access to the system, you're depriving them of the ability to provide a better answer overall. And
To take your example, so the street's full of potholes. I want a curb cut permit because I want to put a new house on the street, and the city says, there's just too much traffic, it's full of potholes. If you want to pay to fix the potholes, then we'll give you the permit. But these potholes are a problem for the entire community, not just for the person that's trying to get a new driveway.
I did indicate that it was not a perfect analogy, but even so, I think you do find that in some situations, in some communities, that has been the approach of having the adjoining property owners pay for pothole repair.
Is it clear in the record that there was, in fact, a moratorium?
Yes, it is, and in fact, it appears in the ACO itself, which notes that there was a moratorium.
I'm sorry.
And the moratorium would have continued in the absence of the agreement represented by the ACO that provided for this regulatory scheme to ensure that if there were going to be additions to the system, that there would be adequate capacity to handle it. And that's what they were purchasing with the fee, additional capacity.
But as I understand the facts, and maybe I misunderstand the facts, when, for example, Denver Street LLC wanted to hook up, there actually was sufficient capacity in the bank to allow them to do that. So it wasn't like more capacity had to be created for that purpose. The bank already had sufficient capacity.
The bank had that capacity, but the funds were paid to reimburse the community for the cost to generate that additional capacity, which again is on a short-term kind of basis. If you look at the testimony of the engineer, this is far more complex than filling potholes. You have an entirely underground system. You have pipes that can have very subtle kinds of leaks, and he spoke in terms of water migration. You can fix one part of the pipe, and then all of a sudden, a few yards away, the pipe can give way and have a problem. And so this kind of approach of patching potholes really is a short-term kind of fix, and the community ought to have the benefit of being able to plan long-term.
I guess I was a little confused by your analogy because I was thinking maybe you were going to say the opposite, because I take it, and maybe this is I'm not sure if it's a difference of Barry or not, but I take it your point is by doing this, you are allowing the developers to join much sooner than they otherwise would, because otherwise, you're going to have to wait until the town actually fixes the entire system, whereas this is a as-you-go basis. But basically, the point of the, if I understand correctly, the point of the requirement is this developer is neutral as to increasing the II because of the contribution.
Yes,
Is
that's correct.
So in some ways, it's sort of like filling the potholes.
Well, except that you've had the developer pay for that short-term fix so
Right.
that the capacity is there. And in fact, what happened on the ground, this is not part of the record, but about a year and a half ago, the town entered into a new ACO with the DEP, which eliminated the requirement of the sewer bank, because after the 6-year period, sufficient progress had been made so that it was no longer necessary, and that is frequently what happens in communities after progress has been made. The master plan was originally a 10-year plan, and conceivably it could have taken the full 10 years to reach that point. In this instance, it took shorter. But if you look at the effect on the developer, if the developer had been barred from making the developments in 2005 and 2006 and had to wait until 2010, I would suggest that the real estate market was in very different condition in 2005, 2006, and if they had to do their development in 2010, we would be facing a very unhappy group of developers.
Probably be facing no developers.
Yes.
But is it the case that if I understood correctly, that the ratio for the fee went down at the same rate that the ratio was going down in terms of the sewer bank? Is it, in other words, 10 to 1, 6 to 1, 4 to 1, or whatever those numbers were? Is that
Yes,
right?
the fee was adjusted downward when the ratio was adjusted downward, so that they were initially paying a fee of 10 to 1 for the amount of gallonage that they were using. And when that was removed, the ratio went to 6 to 1 and then 4 to 1 later on. With regard to whether or not that fee was reasonable, that fee was reasonably related to the cost of ensuring that there was capacity to join the system. And one final point with regard to the capacity issue. If you look at the statutes regulating connections to sewers, and I think it's Chapter 83, Section 3, it is written in mandatory language that a community has to allow a connection, but the case law is clearly established that an exception to that is when there is a capacity problem. The city or town only has to permit a connection if there is the capacity to join.
Well, so how would this have worked? Danvers, we'll just take, not Danvers, Denver Street, we'll assume they apply, and in the sewer bank there is a sufficient capacity to permit them to use that capacity without violating this agreement with DEP. Would you still be able to say no? Because there would be sufficient capacity to allow them to participate. That may cut off the next person, but there would be sufficient.
Right. Under the statute, no. Under with or without a fee, Your Honor.
No, without a fee. Let's assume
without a fee.
Denver said we.
You mean under 83.1, is that what the statute you're talking about?
Right. Under Chapter 83, we would have to let them join. But the effect of allowing access at that point without reimbursing the community for the short-term work done in order to create the capacity would indeed place the community in the position of having to sacrifice the long-term for the benefit of the short-term in order to continue permitting development. And that's what the fee was really designed to do, was to permit the community to maintain its substantial amount of money that's being put into this project and not sacrifice at the expense of the long term at the expense of the short term.
Would allowing new sewer hookups without a fee be in violation of the ACO?
Only if there was not financial capacity to complete the master plan. The ACO just speaks generally in terms of the town having to satisfy DEP that the town had the financial ability to fulfill the obligations of the ACO. If the and in this instance, that meant creating the sewer bank and having the regulatory fee. So I don't know whether DEP would have been satisfied in the absence of a fee, but that was the general standard that we were meeting with DEP.
So it was the town which decided to impose this fee upon the new sewer hookups, not the state.
Well, I would say that it was a partnership, state and local.
Because they approved your proposal.
They approved the proposal, correct. And it was tailored in a way to avoid the problems with the Danvers case because this was only a small piece of the pie. The town had a 10-year, $27 million overall sewer improvement system. In the Danvers case, there's no indication in the court's decision that anything other than the permit fees were being used to pay for the improvements, so that they were, at least according to the way that I read the case, they were improving the entire town system on the backs of the new users only. That's not the case here.
Oh, I'm just trying to understand your last point. In Danvers, you say the developer's fees that's the only source of money for the entire system. Here, it is one source among a number for when you're looking at the entire system.
That's correct, Your Honor. And so that the particularized benefit is that they are actually paying for access as opposed to paying to repair the system as a whole to benefit the community as a whole.
Well, I take it they're paying both. I mean, I assume that somehow this, how much, $26 million plan is being paid for by assessments on those, all of those hooked into the sewer system, yes?
Yes, and all taxpayers through a bond issue.
Right, okay.
Thank you.
Thank you very much, Your Honor.
May it please the Court. My name is James Senior, and I represent the appellants. Skipping to the particularized benefit is a benefit to the town of Saugus because it skips one, I think, very telling point, and that is that a fee, to be valid, is imposed to compensate the municipality for an expense which was incurred as a result of something that the fee payer did. For example, water users. The fee is to compensate for the cost of producing the water. Same with sewer. A permit applicant costs the town money because the permit has to be reviewed, et cetera. In skipping to the particularized benefit argument, it gets much more complicated. If we back up one step, let's look at what these appellants cost the town. And the answer is nothing. There was no expense incurred by the town of Saugus because of any action of these applicants. Any expense incurred by the town of Saugus was because Saugus, through a lack of maintenance of its sewer system for over 30 years, had let it fall into disrepair.
But was there a moratorium on sewer hookups?
Yes, there was.
And so that LLC, Denver Street could not have hooked into the sewer system?
Well, initially, no. However, the town of Saugus made substantial inroads and deposited a lot of gallons. The sewer bank, as you know, is not money. The sewer bank is gallons. They made substantial inroads and enough to accommodate all of these plaintiffs.
But who imposed the moratorium?
DEP did.
And,
by a
and
consent decree.
if you wanted to hook up into the sewer system, would you have had to obtain the approval of DEP?
No,
Whose approval would you have to have obtained?
the town of Saugus.
Okay. Could the town have granted you a hookup in light of the moratorium?
Not immediately, but before these applicants, yes.
Could I ask you this just in relation to that? But the sewer bank, you're judging that on the sewer bank, right?
Correct.
But the sewer bank was only created as part of this whole plan, wasn't it?
Correct. However, the town of Saugus put many, many, many gallons, and enough to satisfy all of these applicants, into the sewer bank by merely preventing residents from pumping water from their basements into the sanitary sewer system. Once that was done, there were enough gallons, and that was at very, very minimal cost.
So did the DEP lift the moratorium as a result of that?
Yes.
They did lift
Well, they lifted it as a result of the sewer bank being implemented.
Okay, so the only way that you could tie in, the only way you could get around the moratorium was to pay the fee into the sewer bank, or through the sewer bank process.
Only because Saugus imposed a fee, not because DEP did.
Well,
DEP
DEP
merely
accepted that mechanism as a means of
They did.
lifting the moratorium so that your clients could tie into the
They
sewer
did.
bank.
They did. I would point out, however, that the question was asked later, was the fee or the sewer bank to make the applicants neutral in terms of any I&I problems? And the answer is it was not neutral. It was 10 times as much. The question was asked earlier as to whether or not Saugus reduced the fee as certain benchmarks were achieved under the DEP consent order. The record is clear. They did not. They delayed, I think it was a year or more, on each reduction because they were trying to raise revenues. A tax is to raise revenues. They were using this to raise revenues. A fee is to compensate the town in proportion to what's being caused by the applicant. In order for the town of Saugus to prevail here today, this court must accept the proposition that there does not have to be a causal relationship between anything the applicant did and the cost incurred. That's the only way this court could find in favor of the town of Saugus. And if that were the conclusion in this case, that would mean that the Emerson case and every other case after that is no longer meaningful. It would also mean that the distinction between a tax, where there doesn't have to be a causal relationship between anything a person did and the tax, there just has to be a relationship between the value of your property and the tax. In the case of a fee, there's got to be a relationship between what you cost the town and what they're charging you. In this case, I could argue they charged us 10 times what it cost the town. But that's not the fundamental argument. The fundamental argument is that the town of Saugus was going to incur this expense whether there was an applicant to tie in or not.
But you weren't going to be able to tie in light of the moratorium.
That's
Could you clarify that point? Because I'm not quite sure you're talking about the same thing. When you're, let's take Denver Street, because there are other clients here. When your client applied to tie in and there was adequate gallons in the sewer bank,
correct.
Was there a moratorium?
No. The moratorium ended when the sewer bank was established. The rules of the sewer bank were you have to have 10 times as many gallons in the bank as you're introducing by the new applicant. There were 10 times as many gallons in the bank at all times when these applicants applied.
But the sewer bank was created in order to lift the moratorium, wasn't it?
That is correct.
Okay.
But it cost nothing. I asked the question, and the town manager, when I said to him, what was the cost that you, the town, had to spend because of these people wanting to enter the sewer system? And he said, I can't calculate that.
So if the town did not use the sewer bank, they would have been under some obligation to remediate the problem.
Oh, absolutely.
Okay.
The
and
idea
if they did not use the sewer bank, some other means would have had to have taken,
Absolutely.
had to fall into place. But in the meantime, the DEP was not going to permit any additional tie-ins to the sewer system.
Until there was a sewer bank established.
Or until some mechanism was
Correct.
established to satisfy
Correct.
DEP.
But the cost of this money was spent on repairing inflow and infiltration. My clients will pay, as users of the sewer system, their fair share of fixing. The users of the sewer system, well, in addition to the administration who did nothing for 30 years to maintain it, the users of the sewer system are the cause of the expense.
What difference does it make?
What difference does it make?
Your client paid a fee in order to tie into a sewer system that the DEP otherwise would have not let them do.
Well, the DEP didn't mandate the fee, but
They
I understand what you're saying.
The DEP mandated they mandated, they created the moratorium.
Correct.
And a process was worked out to allow people to tie into the sewer system, notwithstanding they would lift the moratorium in consideration of the sewer bank.
Correct. In consideration of the sewer bank, not in consideration of the fee. And
But paying the fee was required under this. I mean,
no.
But the sewer bank was just gallons. It was gallons. You could only
sewer
add
bank
one new gallon of waste if the town has taken 10 out.
Right.
So the town took, as I understand your argument, the town took out 10, let's call it, by imposing some restrictions on what people could do. That created capacity, and the fee part of it was something the town imposed in order to further improve the system.
I agree with one exception. It didn't really create capacity. The capacity was there. This is just patching
The
leaks.
fee didn't create capacity.
The fee didn't create it.
but the fee was part of the sewer bank. It was part of the whole sewer bank process. It was a mechanism that was designed to get cash flow to remediate the problem.
The Emerson College case clearly says that a fee is to compensate a town for an expense incurred because of something the fee payer did. It goes on to say it has to have a rational relationship to the cost that was incurred by the town. My point is that there was no cost incurred by the town as a result of these new entrants coming in. The DEP didn't just say there's a moratorium and nobody can enter until you do a sewer bank. DEP said you have to fix the problem. And by the way, there's a moratorium, and you're going to have 10 times as many because this problem is by the way, in the Danvers case, I think it started at 4 to 1. The testimony in this case was that Saugus had created such a problem that they wanted 10-to-1 removal. And I'm not talking money.
Well, I didn't need to go to Saugus if I didn't like it. I mean, you know,
What's that?
You're very critical of the town of Saugus over 30 years, but your client was
Well,
trying
only
to
because
get
I'm trying
there.
to drive home the point that it wasn't my clients that caused the problem, and that Emerson says that the fee is supposed to compensate the town for something that my clients cost the town. And my clients didn't cost the town anything. It was the users that cost the town.
But your client, the benefit that your client received was the ability to tie into the sewer system at that point in time.
Which cost the town nothing.
Well, they couldn't have done it without the sewer bank and without collecting the fee to do that.
That's correct, but that didn't cost the town anything.
But new sewer hookups, by definition, add a burden to the amount of sewage,
The sewer system had if it had been in good shape.
which it wasn't.
Had the capacity to, it wasn't a matter of having to add a pumping station or having to add a sewer treatment plant.
But it's the same thing, though. If the system doesn't work because it's got holes all the way through it, it's the same as not having the capacity.
Well, the earlier analogy of the potholes in the street is similar to what we're talking about here. I want to build on the street. Well, fix the potholes because they're there. And we don't want you driving over and I understand it's different because there's not an environmental aspect to things. But if my clients didn't cause the expense, then Emerson College says that they can't be charged for it. Otherwise, if you're going to say there doesn't have to be a causal connection between what my clients did and the cost that was incurred, then rational relationship to what cost? To any cost?
Your client is getting the benefit of tying into an overloaded system and contributing to the problem for the privilege of paying additional money.
In terms of getting a benefit, yes. However, the principal benefit, and by the way, in the Emerson College case, for example, it was a question of having to buy fire equipment that was in excess of what most people needed, and if your building was of a certain size, you had to pay an extra tax. Well, certainly those people were getting a benefit by having the oversized or larger equipment, but the court held that just because they got a benefit doesn't mean that it was the particular benefit and that the town wasn't getting a benefit. Who was getting a benefit out of the major benefit? What was the real major benefit and purpose of spending money?
But why do they have to even show that? Isn't it enough that your client received a particularized benefit?
No.
Why not?
Because a fee is to compensate the town for a cost caused by my clients. And there was no cost caused by my client, number one. Number
Well,
two,
there was. They were adding additional sewage.
well, there was not a cost caused by my client. The town had to incur
They could not have added that sewage
and they
unless
still,
the DEP raised the moratorium.
and they still would have had to have incurred the cost of fixing the sewer system. The environment,
And it might have taken 10 years.
the cost would have been more if it took 10 years, most likely.
But your client, the benefit that your client received for paying that extra money was the privilege of an immediate tie-in.
My client received that benefit, correct. I do not believe that that is a particularized benefit as defined by Emerson and the following cases. I believe that the appeals court, in this case, and the appeals court in Berry was correct. That to call it a particularized benefit when all you're getting is what everyone else already has, it doesn't make it in terms of a particularized benefit. And again, I sound like a broken record, but I just looking at what the definition of a legal fee is, to compensate the town for an expense caused by my clients.
Let's take a different hypothetical. Let's assume the Saugus system was literally at capacity, and you wanted to develop a huge new section of town, and the town said, in order for us to accommodate that, we're going to have to expand the filtration plant or the sewer processing plant. That's a major expense. Can we charge you for that?
I believe you can. New infrastructure is appropriate. If it's literally at capacity, and it's not a question of repairing a system, It's a question of actually expanding the system.
It's the Bertone case, for example.
Bertone, that's what Bertone says. There is not a single case in that line that calls it a legitimate fee for doing something unless there's new infrastructure involved. And this case, there was no new infrastructure involved, and that's why I go back to it was repair. Thank you.
Thank you, sir. We have one more case. All right.
Yeah, oh, yeah.
Yes, sir. Good morning.
Good morning, Chief Justice. May it please the Court. Peter Heffernan on behalf of the Committee for Public Counsel Services. Your Honor, the underlying matter here is an adoption proceeding initiated by the guardians of the subject child, to which the indigent father objected. And because the father objected, the court was required to proceed with the adoption to consider termination of parental rights under Section 3A of the Adoption Statute, Chapter 10. 210. The court, in this matter, appointed counsel to the child and the father. There is no established right to counsel under Section 3A, and in the probate and family court, some judges are appointing and some judges are not.
Can I just ask you a question? With respect to the child, if this were the department seeking to terminate, would the child by statute get counsel? Is that right?
That is correct, Your Honor.
So, but the problem here is there's no statute. I mean, the parents are a different matter, but with respect to the child, there's no statute that applies when you have a situation like that.
That is correct.
And so then that's why you need to, in your view, it becomes a constitutional question because there's no intervening statute that
Correct.
solves the problem.
Correct, Your Honor.
And I gather the Constitution must be ours in view of Lassiter.
Indeed, Your Honor. We're talking about the Massachusetts Declaration of Rights and JKB and the reasoning in JP with respect to the due process need for counsel. And at the outset, I'd like to just make two brief points. We're talking about a very small number of cases under 3A annually. The probate and family court does not break down their adoption proceedings, but their highest estimate is no more than 100 cases annually of contested private adoption. And even a smaller number of those would be involving indigent parent respondents. To put that in context, there's more than 8,000 child welfare cases, care and protections, and SHINs combined filed annually. So we're talking about a small fraction of the overall child welfare appointments statewide. Additionally, the CPCS already has a system in place for assigning and paying and compensating these attorneys. There would be no additional, or very little additional administrative burden as a result of extending the right to counsel in these cases.
When you say paying these attorneys, you mean you have that system vis-a-vis when the department is seeking it? Or do you mean that you have it for these kinds of cases as well?
We have it for these kinds. We already have a list. Each court, each probate and family court in the Commonwealth has a list of certified attorneys that are certified for these cases as well as termination cases in another context.
Okay.
Now, the consequence of what you're asking for, I gather, is that when a guardian seeks to adopt, and that would result in the termination of parental rights, then the parents would have attorney appointed for them, correct?
Correct, and the child.
And the child,
yes.
But not necessarily the person seeking to adopt.
No, Your Honor, and I think the bright line between is the fundamental rights at stake. The petitioner in this case does not have a fundamental right to family integrity with respect to an existing parent-child relationship that is at risk through the court order of being extinguished personally. I think that is the bright line between the appointment, Your Honor's question.
If the parent in this kind of situation, or when the department is seeking to terminate, if the parent doesn't object, does it ever happen that the child, and then the child doesn't get counsel, correct?
That is correct. There is no right to counsel in consented adoption proceedings, and
So
we're
the
not.
parents control the whole, I mean, in that sense, the parents control the situation.
For children that are 12 and under, that is the case. Children that are over 12 have the right to consent. They can't be adopted without their consent.
So then, even though the parent might agree, the child would get counsel in that situation?
I'm not sure how that situation would be dealt with in the. I think by statute, if the child withholds his consent, I'm not sure there's a mechanism to override the child's consent. Your Honor, due process requires the
No,
appointment
sir,
of counsel.
before you get there, I gather that this would not have any effect. No, I'm sorry. The procedure that you would be in place is the parent would have to come to court and say, I object.
Yes, Your Honor.
So it would also, the counsel would be appointed only upon the parent pro se coming to court and saying, I object.
That's correct. In this case, the father received notice of the adoption petition. He filed his objection, and that would be the point at which the court would appoint counsel for that father and for the child in that proceeding. Your Honor, this court in JKB held that a parent facing the permanent loss of their parent-child relationship cannot have a meaningful right to a hearing without the assistance of counsel. And by its reasoning and its holding, it applies to all proceedings under Section 3, Section 8 proceedings and Section B. The court doesn't distinguish between those two sections of the statute. It does state that the need for counsel is particularly so where the state, with its resources, is the petitioner. But that does not make the need any less so with respect to other contexts. And it's important to note that the reasoning of JKB, the complexity of these cases, the significant rights at stake, and the state's interest in having these cases carefully and correctly decided applies to both proceedings under 3A and 3B. And while JKB only addressed the question of the right to counsel for children, I would argue that its reasoning and holding apply equally in the context of I'm sorry, parents. I apologize.
Yeah.
With respect to parents, I argued that it applies equally to children. In fact, even more so where a pro se parent at least has the opportunity to stand up and present his or her position to the court. A child without counsel has no voice in these proceedings. The state has recognized the need for having children have a voice in child custody proceedings by providing for a right to counsel in many other contexts where the right to counsel is not, where the rights at stake are not nearly as dire.
A question about right to counsel for children who are quite young, under the age of 4 or 3, can't articulate their positions. In Massachusetts, we've said that counsel represents the wishes of the client.
Yes, Your Honor.
And when there's an incompetent, like a very young child, you need a GAL. Isn't that correct?
Not necessarily. We are a substituted judgment jurisdiction where the counsel, the job of counsel is to determine were the child able to speak. It's not necessarily what's in the best interest of the child. The analysis is, were that child able to communicate to me what he or she what his position is, what would that position be? And there's a distinction between that and clearly a best interest, what would be best for this child. The obvious example is an aunt of limited resources as opposed to a foster home with more resources. The question is, given all things considered, the child standing in that child's shoes, the prior relationship with that aunt, et cetera, may lead the child's counsel to find that the child's position is for placement with the relative as opposed to a foster placement.
We've articulated that the attorney does the substituted judgment, or
Yes,
that the substituted judgment is made.
The attorney, in that case, substitutes his or her judgment. Well, under that analysis, the attorney reaches the position of the child. The reasoning of JKP applies equally to children as it applies to parents, and that is the same complexity of the cases and the same rights at stake. Further, Your Honors, the statute creates a classification between two similarly situated groups, parents facing and children facing the termination of their parental rights or the parent-child relationship are similarly situated regardless of whether the proceedings are under 3A or 3B. Because this classification in disparate treatment, where counsel is provided under 3B but not under 3A, because this affects a fundamental right, the appropriate level for review in equal protection analysis is strict scrutiny. And here, there is no compelling state interest to deny counsel to this small category of litigants, given that the rights at stake are so significant and the cost to the Commonwealth is relatively small. Thank you.
Thank you very much.